Reflections of Unclos 3 Critical Junctures. I used to speak for the group of 77 in the Law of the Sea Conference. In fact, I did so until the 30th of April, the day the convention was adopted. As of the 1st of May, I have been working with the Secretary General of the United Nations, for whom I am not speaking today either. You will find that because of the identity crisis I am suffering at the moment, this being my first public appearance on the Law of the Sea since the 30th of April, my remarks will sound more like nostalgic musing than anything else. Those of you who recall me as a firebrand or extremist, who by the way were always strong, will, I am sure, be very disappointed. This will be an anticlimax. Let me tell you a bit about my identity crisis. Over the years, my identity as a representative of Peru to the Law of the Sea Conference, and before that to the Seabed Committee, had become somewhat blurred. Tommy Koh, who is a friend of 15 years, was recalling that I was a spokesman on seabed issues from 1974 onward. I tried to subsume the position of Peru on seabed issues into the position of the Group of 77 and lost the habit of speaking for Peru. When I was asked to contribute to a delegation general statement regarding the seabed, I had considerable difficulty remembering what Peru's individual position was. Chairing the group of 77 was a considerable experience, and I could perhaps best describe my identity as a spokesman, or at least my genealogy, more or less as the grandson of two couples constituted by Buckminster Fuller, Avril Knievel, Isadora Duncan, and Gina Lola Brigida in her role in Trappist. You are free to combine and permute those two couples as you wish. That is how one bred a spokesman for the group of 77. Now, however, I am not sure what I am. I know, to quote Eliot, that I am not Prince Hamlet nor was mean to be. If anything, I am attendant lord, one that will do to swell a progress, start a scene or two, advise the prince. I am certainly no longer a prince, if ever I was one. Now looking back on the Law of the Sea Conference, and on this I am departing somewhat from the term of reference of this symposium, and I do so to some extent in order to flee from the problem of what to say, and in what capacity to say it. I would like to say that if the Law of the Sea Conference had to retrace its step and begin again from scratch, I don't think it would be well advised to do things much differently from the way it did. I think that if we delve into the approach followed by the Law of the Sea Conference, it provides many lessons and many answers to some of the doubts which were expressed even today at the symposium. You will recall that, departing from the criteria followed at the 1958 Conference on the Law of the Sea, the most recent conference adopted a comprehensive approach to the problem. This approach wasn't merely comprehensive in the sense that the 1958 conference was comprehensive, but rather the new convention was drafted as a package, whereas in 1958 5 conventions were attempted and 4 were approved. I think this was necessary in order to impose a sort of discipline on the conference and on states participating in the conference, and to achieve an agreement in which the result would be broadly acceptable to all. The straitjacket of a package deal was precisely what was needed to achieve that objective. Not only was there the possibility of achieving small trade-off, local trade-off within part of the mandate of the conference, there was also the overall package which created a tension that obliged the major bloc of participants in the conference to lock their horn in a way that made them inseparable. This overall trade-off was essentially between communication and resource interests. It is of course difficult to trace such a broad distinction rigorously. One should not be categorical about it because the Law of the Sea Conference was basically a pragmatic exercise, one in which clear-cut distinction as between developed and developing countries didn't occur in the pervasive way in which they have occurred in negotiation between the North and the South, for instance on trade and development issues. Indeed, I think that the record of the conference was good in keeping away what Frederick Gibson referred to as forces of darkness, and if I may dip into pop culture again, what I would call the Darth Vader of multilateral conferences, ideology. I feel that were we to retrace our step, we would be well advised to take the decisions that were in fact taken as we went along, and I revert to landmark decisions such as the one taken in 1969 on the comprehensive approach to the conference. That was as long ago as 1969. The issue of whether one should address law of the sea problem in manageable package, which might have been more practical, but probably would have resulted in isolated sectorial convention, such as those of 1958, which would have been signed and ratified by relatively small numbers of states which adhered to the purposes of those packages. The conference was well advised to adopt the comprehensive approach where one had to take the good with the bad. Another landmark decision was the one taken in 1974 when the conference adopted the rules of procedure which provided, as you know, for an attempt at reaching consensus and failing that resort to a vote. The conference record in resorting to a vote is also a very good one. It only did so ultimately and with a result which seemed to confirm the consensus approach rather than anything else. I do not believe you can call 130 vote anything less than that. Another adroit decision in 1974 in the context of the seabed negotiation was that of shirking the drafting of a full-fledged mining code, which would have meant including in the convention the detailed rules and regulations regarding seabed mining. I think it was very wise of the conference to defer the drafting of a mining code stage to the preparatory commission of the Seabed Authority. Among the reasons this deferral was wise, and this is related to the symposium theme of where now, is that we have gained some time. This is an important consideration which should be borne in mind particularly by those who are having hesitation about signing the convention because of its seabed mining aspect. One can refer to several crucial decisions in 1976, one of them being the essential package on the exclusive economic zone, which in miniature symbolized the large trade-off which I referred to earlier between navigation or communication and the resources to be held by coastal states. This decision also deftly skirted the ideological issues which plagued several countries on both sides of the fence. I will be getting back to that later. Around 1976, or perhaps shortly thereafter, the landlocked and geographically disadvantaged countries, a major group both in its size and in the importance of its input into the conference, determined in a very statesman-like way that they had achieved as much as it was possible to obtain from the law of the sea conference, given the existing realities. They didn't do what they could have done, which was to scuttle the conference and lay to waste the work of years by blocking agreement on other remaining aspects. Rather, they went along in a pragmatic spirit, and there is the quintessential landmark of a non-ideological, pragmatic success in negotiation, the parallel system for seabed mining, which essentially arose or was proposed in 1976. If it responds to any ideology, I cannot think of anyone who would subscribe to it. It is a compromise from all point of view. Lastly, of course, was a decision taken in 1982 to proceed to adoption of the convention. Thank you.